We're going to get started with our second panel on local approaches to the duty to consult. We have a very distinguished group of panelists to discuss this, covering a broad range. I've got their bios in front of me, but I understand that there is a printed pamphlet containing the bios, so I'm not going to go through them at length. The order that we're going to go in, we're going to start with Professor David Good from the University of Western Ontario. He's going to talk about, this is going to be really interesting, the duty to consult is viewed from the perspective of an exploration company. So that's going to be, I think it's going to move our discussion forward. Then next, we're going to hear from Mr. David Launay. He'll tell you about who he is. He's deputy minister with the Ministry of Northern Development of Mines, but apparently the most interesting thing about him I just learned is that he once jammed with the Doors. So we should save one question at least after that. And last but certainly not least will be Bryce Edwards, who practices at, I'm just going to say OKT, and he can tell you how to pronounce the first word of that law firm. And as Bryce told me, he's very falsely modest. He's done some stuff. That's sort of the extent of his bio. So he's going to tell you more about what he's doing, and he's going to be talking about how First Nations have responded to Ontario's recent initiatives in the north. So without further ado, I'll turn it over to Professor Good.
Well, good morning, everybody. Can you hear me okay? Before I start, I'd just like to add a comment to something that Pete said earlier, talking about exploration and mining sustainability. Maybe an individual mine is not sustainable, but the exploration sector, I would say, is truly sustainable. And I'll get into that as I go through this. You'll see what I mean. So, okay. So I really like this photo. I consider it to be a perfect metaphor for what we do as geologists involved in exploration for mineral deposits. As the picture shows, we like to work alone or in small groups, and we typically keep our heads down. We focus on what we see in front of us and like to build complicated geologic models that explain what we see. The reason we build these models is it so that we can make predictions on the size and type of the potential mineral deposit, and also where in the surrounding area we have to look to find more. But I'm not here to describe geology today. I'm really here to discuss what that geologist sees when he lifts his head. If he lifts his head, he would see the hole in the forest that was cleared so that he could examine that outcrop. And if he turns around and looks behind him, he would see the trail that was cut in the forest to allow access to that outcrop. And activities such as these have potential impact on the protected rights of First Nations protected rights of First Nations in Section 35 of the Constitution Act. Real consultation from the mineral sector's point of view, real consultation, as discussed today, implies that exploration plans must remain flexible, and the company must be willing to adapt. So that's the main theme. But consultation, next slide, that's me. I've got a right and a left button. Okay, am I pointing it that way or this way? Doesn't matter. Good start. But consultation is also complicated by the incredible complexity of our industry. In this figure illustrating the mining cycle, we can subdivide the diagram into two groups, with exploration on the left and mining and development on the right. Everybody involved with the left side are working tirelessly to try and get their projects over to the right side. If you could somehow calculate, and this is important, if you could somehow calculate the proportion of companies that actually make that journey from the left side to the right side, the number is probably close to 1 in 1,000. The number could actually be 1 in 500, or it could be 1 in 10,000. But the true number doesn't matter. What actually matters is that this is a very risky industry. It's a very risky business. Whether the number is 500 to 1 or 10,000 to 1, that translates to more than 99% of all exploration projects will not make it to a mine. And that translates directly to more than 99% of all consultation relationships will stay on the left side of the diagram. And that's just the technical aspects. If you include the possibility that society, through their environmental assessment review panels, et cetera, if you include that process and the ability to say no, then maybe that ratio is closer to 1,000,000 to 1. So a very risky business indeed. So what compensation do the First Nations receive for all the work involved in consultation? If the odds are 1,000 to 1 that anything will ever come of their effort. Little wonder that there is a consultation fatigue. I would go so far as to say that consultation from the First Nations point of view may not be sustainable. And I think this is something that the mining sector needs to take seriously. Just to finish this discussion, the other 0.1% of consultation relationships on the right side of the diagram will be governed by more formal and more complicated set of agreements, including MOUs, confidentiality agreements, impact benefit agreements, etc. These agreements are very time-consuming to negotiate and typically confidential. But I think that goes beyond the scope of what we're here to discuss this morning. So now we get to the question of what does the consultation process look like on the left side of the diagram? And that's what I'll be focusing on. How do you build the trust and respect between two different cultures? That is, the culture of the scientists and the engineers who are driven by the needs of the business, and the culture of the First Nations communities who are exercising their rights to, for instance, hunt, fish, trap, and gather, among other things. In our industry, finding ore deposits is getting harder and harder as the easiest discoveries on the surface have already been made. To be successful, we need to look deeper and with more technology to make the discoveries. And so there will always be a need to cut trails and to drill holes. So at what point in the exploration process do you begin consultation, and with whom do you consult? The MNDM provides a valuable service here, as they have created a framework for the public. I don't expect you to read this. I only wanted to show you the processes in place and where you can find it. The charts show that there's a graduated approach to consultation, whereby escalating levels of work will trigger the requirement for either an exploration plan or an exploration permit. And each of the plan or the permit phase lists who does what within each organization and attaches timelines, approximate timelines, so that progress can occur. And most importantly, the chart provides a mechanism for mediation should problems arise. But the question still remains as to what does consultation look like? First of all, let's look at some common underlying fundamentals for the process. First of all, Aboriginal communities and the proponents must be willing to work constructively to understand one another's interests and perspectives and to find practical ways of addressing concerns and realizing opportunities that mineral exploration may have to offer. So the first step is to figure out who should be involved. And that will depend on the scale of, it'll depend to some extent on the scale of your operation and the type of the project. And this will be matched by the MNDM submission of either your exploration plan or your exploration permit. If the project involves very early exploration, then informal discussions could be arranged between the land management staff of the First Nations community and the project manager. If the project is more significant and nearing the feasibility stage, then I would begin with high-level discussions between senior members of the two communities, preferably between the chief and the president of the company. Secondly, it is important that the company make every effort to minimize the disturbance and to clean up afterward, such as shown here at a drill site. The drill sat on the logs. You can see the flag where the drill went in, and there's a collar. And this is about 3 weeks after the drill was pulled off. You can see that we seeded the site. In the past, exploration companies were notorious for leaving a mess. But thankfully, that behavior has changed dramatically over the last 10, 15 years, primarily due to public efforts and government response, and I'll come back to that. Thirdly, it is widely known that there are large gaps in knowledge between the two communities, and these gaps occur in both directions. It's important for the mining community to develop an understanding of the cultural sensitivities of the First Nations community, and the mining company must work towards demystifying the technical jargon that is it's so common in our industry. For instance, what does a drill site look like? How does it work? How big are the clearings, etc. And depending on the size and scope of the project and the relative interest in the community, you should also begin describing some of the more specialized topics of your exploration project. For instance, what are the key milestones for decision making that allow you to continue to make the exploration, to continue with the exploration, or describing in general terms what you envision your operation could look like if results continue to be positive. After all, there's a very big difference between what an underground gold mine operation looks like compared to an open pit base metals mine. So what do you do? If your project is successful and ongoing, then you should set it up for regular meetings, perhaps 3 or 4 a year, it could be 5 or 6, it could be 1 or 2. Each time you have a meeting, you should bring along, again from the company's point of view, you should bring along maps and figures so that you can highlight and discuss, for instance, your 3-year plan. What are your objectives if everything goes well? You should discuss your 1-year plan if all goes well, and if your budget is approved. You should also provide an update for your recent work. Where did you do your drilling? What trails have you cleared, etc. And you should also outline your plans for work leading up to the next meeting. Remembering at all times that the intent of these meetings is to share information and knowledge and to uncover potential problems. If there are problems, you need to find a way to resolve any issues, and you need to do that together. And you also, and probably the most important intent, is to prevent misunderstandings and any surprises. Also, as a courtesy, you should send out simultaneously to the public and the First Nations communities press releases, job postings, or requests for tender. You should also initiate field trips. You want to bring any interested members from the community onto your site, show them your water crossings, trail construction, methods for trench clearing and channel sampling, and drill sites, etc. As I stated earlier, common exploration processes are very closely monitored by various government ministries to ensure compliance of rules and regulations. The First Nations community are not alone in checking to see that exploration activities are environmentally sound. In this case, the water crossings on the project along all trails are permitted by the local Ministry of Natural Resources. The M&R has standards that must be met before approving any crossing, and in most cases the crossings are temporary and plans for removal are in place prior to construction. So when we built that bridge, for example, we already had plans in place and a timeline for removing the bridge. And the Ministry of Labor will make regular unannounced inspection visits to ensure proper safety guidelines are in place and that workers are wearing appropriate personal protection equipment, or that the equipment is properly maintained and in safe working order. These are all signs of a disciplined and organized exploration team, and hopefully a worthy partner to the First Nations communities. So in summary, I believe it is important to begin consultation as soon as possible, to maintain honesty and integrity at every stage by accepting the possibility of compromise, actually accepting the responsibility to make changes to your plan, to promote the sharing of information and knowledge in both directions, and finally, as a note to the geologists in the audience, keep your head up. Thank you.
Thanks, David. That was, I think, some good practical advice and some practical analysis. Just before I start with a couple of remarks I want to make, a lot of talk about government making rules. We're pretty good at doing that. Whether they all work together, and that's another question. I think there'd be different views in this audience about that. So I'm going to try to stick to the rule of 5 to 10 minutes here for my remarks. But the first life lesson I just want to pass on is that, in part, the reason that Bryce Edwards knows that I jammed with the Doors is because he lives next door to the guitar player in the band that I was in at the time, which, well, those of you who know when Jim Morrison died, was a long time ago. And so the life lesson in this, so Bryce and I have been on the other side of negotiations and facilitation and conversations for quite a few years now. And so the other side of this is you always just have to be careful. Don't ever make enemies of the people that you're dealing with, because you just never know how they're going to pop up in your life. And secondly, if you're whining and complaining about the other side in the backyard over a barbecue, do it really quietly, because you just never know. So, well, so just maybe a few things to start off here. And I have no idea how hard rock leads to me being in the ministry, as we affectionately say in government, the ministry of rocks, but there's somewhere cosmically. So I want to just make a few comments on the Ring of Fire and our approach with First Nations, and try to link in a bit the environment that Janet and others spoke to, and also economic development and infrastructure. So for a number of years, I think we've been trying to take an approach in government that recognizes the role of First Nations. I think Bryce will speak to this a little bit as well, but we came out with an approach around the Mining Act modernization, which puts right at the front end of the Mining Act that we were going to do this, any of our activity, with full respect of treaty and Aboriginal rights. This is constitutional law, but this was not in our act at the time. And a lot of the amendments to the Mining Act have tried to address the issue of consultation, which you heard some very practical suggestions about. But I think more than that, what we've also been trying to look at is to go beyond a duty to consult, i.e. we want to do something, here's what we want to do, what do you think about it, okay, we'll change a little bit, and back and forth, to actual partnership. And I think that partnership is the only way that we're going to go forward, government working with First Nations, companies working with First Nations, and with Métis and Aboriginal people. So this was the thinking behind what we were trying to do in the Far North Act, which became very controversial because it was trying to achieve both environmental goals of 50% protection in the Far North, as well as First Nation partnership. Just on the environmental goal, by the way, because there's often a contrast between Quebec and Ontario on this point. People say, well, the Plan Nord, it's all about economic development, and Quebec is so much more tuned in to their companies, and they're really trying to get something going. Plan Nord is clearly based on reaching a 50% protection objective. It's written into the Act. The Premier of the day was the Premier Charest, was the ex-Minister of Environment federally, and this was baked into the Act. But what we were trying to do with the Far North Act in Ontario was to give a partnership around decision-making. So all the land use planning that would occur in the Far North had to have mutual agreement between the government and First Nations. There's a lot that can be debated, and Adam Fiddler, who was very involved in that, who's now a student here, can tell you a lot about the details, as can Bryce, but around exceptions and exemptions and that, things that you always find in legislation. But the intent was to have this partnership where there was basically both parties got to say no. And if you say no, then the plan doesn't go forward. So for those of you who are in the law faculty and are looking to this in the future, sooner or later somebody's going to take this to court to see whether the province really has the authority to, in law, hand over even that modicum of decision-making to First Nations. So then we went from there into the Ring of Fire regional table. Many of you will know, I won't repeat all the facts, but we've got a negotiation that's going on. We've got a framework agreement that's based on principles of mutuality, mutual understanding, mutual respect, mutual accountability, and then looks at 4 or 5 big topic areas: resource revenue sharing, infrastructure, et cetera. We can talk about, and Bryce will talk about, where that's at and how things are going, but the fundamental framing of it is this partnership framing that I think we're trying to achieve so that we're actually able to move forward in projects, not just with agreement by First Nations, but with participation by First Nations. We're doing that in a framework of looking at the environment, and as I know we're getting taped and all of that, so just to be provocative, I'm the government guy who, I agree with a lot of what Janet Sumner of the Wildlands League says. What I agree with is the general framing that if we don't protect the environment for the future, nothing else counts. You can't have future economic development if you don't have a planet to have that development on, in, with, through. And that's in part why the government is looking at a cap and trade system and really seriously trying to take on the climate change issue. And that would be the way I've looked at things in Ministry of Natural Resources, Ministry of Aboriginal Affairs, and now MNDM. So having said that, we have made a decision to move ahead with the Ring of Fire, thinking that we can mitigate the challenges that are going to happen. And Janet's pointed out a number of the challenges that we have, and Glenn spoke to some of the ways that the company is looking at them. And we could get into some more of that, of how we think in government we can address some of this, but that's absolutely critical. But I want to just finish on the economic development and the infrastructure. If this were a mining project, and if this were a mining project in the Timmins area, or you're going to hear about the New Gold project that's happening in the Fort Francis area, I think this project would have been done. I think the Chromite project would have been done. And certainly the Eagle's Nest nickel project would be done if this were only a mining project and if it was in areas essentially that had infrastructure and a history of working with First Nations. The biggest challenge with this project is that it's in an area, and I think somebody, maybe Glenn spoke to this, or maybe Raymond, this is in an area where there hasn't been development, so everything is new, environment, economic development, and it's in an area that does not have infrastructure. And the big economics issue of this project has been a $1 billion road expansion. And people will know who followed this in the media that we tried to do this through the private sector when Cliffs, which had some deeper pockets, was involved. That didn't work out. And we continue to try to work with the federal government, and who knows what the new election will bring. If you read carefully the federal Liberals' election platform, they don't speak a lot about the Ring of Fire, but they do speak a lot about infrastructure and infrastructure development. So we're hoping that there's going to be good possibility to work in partnership. And we do need to continue to work to provide not only industrial road support for mining development, but also community road access. And so this is the knotty problem going forward. It's at our regional table that Bob Ray and Frank Yakabuchi are the two negotiators for, and it's a big preoccupation inside government about how we're going to move forward with that. So those are my opening remarks, and I look forward to the questions as we go further. Thank you.
Well, thanks very much. Thank you, David. My name is Bryce Edwards. I'm a lawyer. I work in an office in Toronto, but I really work a great deal here in Thunder Bay and points north as well. I worked on the modernization of the Mining Act for Anishinaabe Nation, working closely with Jason Beardy and Stan Beardy, who was Grand Chief at the time, and the chiefs on that. So I'm going to touch a little bit about what happened there, touch on that. I then worked on the Matawa, which was the Northern Table, kind of multilateral, multi-topic negotiating structure that was set up around the same time, and went on for a couple of years with some high hopes at the start, and then ultimately ended crashing on the rocks of the Far North Act. And through all of that, I was legal advisor to Frank Beardy, who was the lead negotiator on that. And I'm now Bob's right-hand man on the Matawa file. He's the lead negotiator, and we're engaging with the government on the Ring of Fire. So I'll sort of take you through those and just talk a little bit about how the duty to consult acts as a driver and what it means and doesn't mean in this situation. So the duty to consult is this at law. It's that if the government has real or constructive knowledge that a decision might have an impact on the exercise of Aboriginal or treaty rights, then it must consult with those who would be impacted. So, there's a lot of words, but basically if you're going to do something that's going to mess up hunting, trapping, fishing, and whatever else is considered a treaty right, then as government, Ontario government, federal government, you talk to the First Nations about it. There's a few things inside this, though, that need to be kind of made more apparent, and they're pretty obvious. One of which is, this is not co-governance. And the duty to consult really, in law, is not about partnership. There's not an equality there. I consult you, but then I decide. That's what that says, and that's what the law says, is that ultimately the government's the decider. And there's all kinds of conditions on that, but nonetheless, the government's the decider. That is not obviously in any way satisfactory to First Nations, because their understanding of what the treaty means legally is quite different, and that the treaty did not surrender jurisdiction over the lands, and that jurisdiction remains with the First Nations. And this doesn't need to be a scary thing. I mean, First Nations make reasonable land use decisions just like any other group. But nonetheless, their point is, look, we have mediated our relationship through treaty. It's law-based. And what that law actually says is shared arrangements. It does not say that the Ontario governments get to make final decisions. So it's this sort of fundamental disagreement in principle that animates a lot of the difficulties that First Nations governments and Ontario and to the federal governments have with one another. But what I'll get to is that it doesn't have to. I mean, this doesn't need to be as big a fight as it is. One of the reasons, and this applies particularly in the far north, one of the reasons that the duty to consult sort of falls short, even though it's a good legal driver, it gets us going, is that it's ultimately going to sort of cap out at, well, we'll consult deeply. And I'd put to you, and this is my view, not on behalf of any First Nation or client, but I'll put to you my view that that's simply out of touch with reality. That the reality of Ontario's far north is that the people that live there are the First Nations. The people that use all of that land are First Nations. They are the only people that have ever lived there and used those lands, and they're still there. And they have a language that's unique. They have culture that's unique. They have laws, traditions, the whole thing. I mean, it's still there. It's still there. And most of us will not go there ever, right? Because there's no roads there. You fly there. And so, these nations are there on this land, and they say, well, by what right can an Ontario government come, hundreds of kilometers north and purport to govern us on this land where we live and nobody else lives? So this is where I think, you sort of crash out, because the reality is that jurisdiction, in the sense of ownership and control, or maybe control, ownership is maybe not a great concept for our purposes, but control over land use decisions. The reality of it is that no matter what any government says or company says, if the First Nations there are not agreed to a project, in reality, it's not happening. That's just the fact of the matter, because they are there. I mean, I suppose that one could send, armies up there, but and that's not going to happen. No one's going to go down that road. So ultimately, the First Nations consent is essential because their jurisdiction is a real thing. So that's the kind of the major, sort of dispute or disagreement between Ontario and First Nations. And the questions we're always facing are, okay, well, is there some way we can still work together? I mean, do we need to have these, do we need to compare solitudes, or can we find ways to work together? And I think the duty to consult has prodded the government towards finding ways like that. And they've made steps in that direction. So the first of which I'd say is the Mining Act was a modest step in that direction, in that it changed the exploration process such that now First Nations have a right to be consulted and receive detailed information about what's being done on the lands. And in addition to that, the government encourages companies to make agreements with those First Nations so that it's not a matter of hoping the company comes to town, but rather having an agreement that's in writing that says they shall come to town and they'll do it in this fashion, we'll get this information, and so forth. So that's an improvement, though it does lead to a risk of consultation fatigue, as has been pointed out. Next up, in Ontario's attempts to come to grips with this, I think, really with this reality that they're not in charge in the North, is the Far North Act. So the Far North Act is a planning mechanism by which both First Nations and Ontario work together to create land use plans, and if there's agreement on that plan, it becomes the law. And that plan basically zones areas for use or not use. So it's a way of essentially translating First Nations laws, say around conservation of a particular river or region, into Ontario's laws, because those land use plans would have the force of law, right? So basically the governments all agree, and then Ontario puts it through in its legal system, and there's a legal backstop now that can be used. And it's not needed against First Nations, but can be used against companies. Which sounds great, and in practice it could work, right? I mean, the idea of if we can all work together and come to an acceptable plan, super. The problem is with the Far North Act that ultimately the cards all remain held by Ontario, because they're at every step of the act. If a First Nation and Ontario can't agree, there is a way for Ontario to simply impose the decision that it wants over the objections of the First Nations. That's not easy under the Act, but it can be done, and it goes all the way up to a cabinet exemption that would override an agreed upon land use plan and simply push it aside and say this project can go ahead because cabinet has exempted it. And that's something that cabinet can just do at its discretion at any time. So that, it was those kinds of things within the Far North Act that led to an otherwise positive initiative about cooperative land use planning to completely founder and result in very, very strong objection from all of the Nan chiefs, who pointed out, I think quite rightly, that this was simply inconsistent with the treaty relationship as they understood it, that Ontario didn't have this kind of jurisdiction, and to assert it was simply a violation of their understanding of the kind of constitutional structure of this country. Nonetheless, land use planning, a good thing. Nations are planning now, and it seems to be working out in some cases. So there's a possibility still of working together there. Then the last one that I'll come to then is the regional framework agreement. So this is downstream of all of these acts that have been changed. And it's a focused agreement to work with the Matawa First Nations on Ring of Fire discussions. And this, to my mind, is getting closer and closer to this, what I started with, this notion of co-governance, shared governance, rather than good stakeholder engagement, and which is really what I think the duty to consult, that's about the best you can get from that. Because it's about sitting down together and looking at how an environmental assessment can be done in a way that it is responsive to community priorities, and looking at how infrastructure projects can move ahead with the information that First Nations need to make decisions from their community priorities about what kind of corridors they want to serve their communities and to protect their region. So it does have a lot of possibility. That's why the chiefs agreed and called for it and agreed to it and signed off with Ontario to proceed on it. And we've been proceeding ever since. So there's a couple questions that come up about this, one of which I'm sure is in Thunder Bay is a question all the time. Well, why isn't there more progress? Why has more not happened? And there's several reasons for that. I think ultimately these kinds of governance engagements are very complex, right? We have 9 nations, 9 chiefs, 9 sets of elders, 9 communities behind those, 9 councils to deal with. We also have various regional organizations, and then we have several different ministries, all of whom have different approaches and concerns. Knitting all of that together is a very time-consuming task, and it involves, unfortunately, a fair bit of stumbling and taking a step back and then taking a step forward. But nonetheless, we have been moving forward on that. Another one, and one of the biggest challenges we face, is that the 9 First Nations governments that I work for don't have a revenue stream, and they don't have a land base. They have reserves, very small reserves that were set by the federal government, but that's it. And you try governing without money and without land. It is impossible. It is an extraordinary challenge. There's no government in the world that can survive without a steady revenue stream and a predictable revenue stream. We do get funding, but that funding is usually on a year-to-year basis. There are all kinds of disputes about the terms and conditions of it. It can burn a lot of energy just trying to make sure you've got the fuel in the tank and you're not driving anywhere yet. You're just trying to make sure that's there. And that is a perennial problem, and I think it will continue. But nonetheless, we are making progress because we have gotten to a pretty good place. The other thing I'd say, and I'll close on this, is that it's a regional framework agreement, but a regional can never substitute for local. That the First Nations themselves, the individual communities, are the ones that are ultimately going to make the decision and are going to make to drive the process, right? So those communities have to be brought along, and that takes a lot of work because they're remote and they don't necessarily have a lot of time to sit and go through the incredibly complex EA rules or what have you. So it takes some time. But that local engagement is absolutely essential. And you say all politics is local. I mean, all consultation has to be local because frankly, it is a kind of politics. And if it's done well, it can lead to good results. I think that's probably my time and then some, so I'll leave it there and look forward to your questions.
Well, thanks for that. In thinking about the overarching theme, I'm just really interested to hear questions from the audience. Reminded me that Aristotle once said that there can be no friendship without equality. And I think that that's a theme that is really coming up in this panel, which is really dealing with the concept of partnership and equality and co-governance and the obstacles that remain to that. So hoping we can have a really good, frank discussion about those challenges. So questions for our panel?